It's my pleasure to bring you the panelists for our business bankruptcy and reorganization presentation today. Um, I look forward to introducing the following. Honorable Judge Colleen Brown. She is the Chief United States Bankruptcy Judge for the District of Vermont. Another of our panelists, Alexandra Edelman, attorney at law for PRIMMER, Piper, Eggleston, and CRAMER, and co-chair of the Vermont Bar Association's bankruptcy section. Don Hayes is a Vermont Law School professor and an attorney at law, and he too is co-chair of the Vermont Bar Association bankruptcy section. And I'd like to turn it over to our panelists.
Thank you, Jeanette. I want to again welcome everyone and begin by just giving you a little bit of a backdrop about how bankruptcy works generally before we get into too many of the details around the small business bankruptcy type of relief in particular. So the underlying premise of bankruptcy is really twofold. It's designed to create an equal distribution of assets among similarly situated creditors and to give the debtor a fresh start. In that context, let me give a little more detail. The equality of distribution has to do with the different categories of debts and making sure that within each of those categories, everyone gets the same distribution. This eliminates the race to the courthouse. Outside of bankruptcy, the creditor who gets to the courthouse first and gets a judgment gets paid first and to the exclusion of others. Bankruptcy tries to put everyone on a level playing field and make sure that everyone in that category is treated the same. On the debtor side of things, there's a fresh start that is a process, essentially. When the bankruptcy case is filed, an automatic stay goes into effect, which freezes all of the creditor action, again, avoiding this rush to the courthouse, and gives the debtor a breathing spell during which the debtor can propose a plan to reorganize and ultimately get a discharge of any of the debts that the debtor is able to discharge or have forgiven under the terms of the bankruptcy code. We'll talk a little bit more about which kinds of debts must be paid and which kinds of debts can be forgiven. And also relevant to this is the fact that Congress didn't intend to have people be destitute. And so there are certain assets that are available to be exempt in a bankruptcy case. And so every creditor gets to keep a certain amount of equity in their home, a certain amount of equity in their car, and certain essential pieces of equipment and furnishings and so on, even before we talk about what assets must be sold to satisfy debts. And when those are all put together, the case is completed and the debtor gets to start fresh without the burdens of those debts, but with the exempt assets still available. So the policies that these are focusing on is maximizing the value of assets and distributions. And this particular program today is focused on the creditor perspective. So this is especially important. And whether the case is a small business case or a different kind of bankruptcy, the policy is the same, that either the debtor or the trustee of the case has the duty to maximize the value of assets and to sell them in the way that's going to bring the best price, specifically to be able to pay the most back to the creditors. If the type of bankruptcy that's filed is a liquidation kind of bankruptcy, that's really the entire focus of the case. If by contrast, and as we're talking about today, it's a reorganization bankruptcy case, then the focus is different. The focus is figuring out how to reorganize and rehabilitate the business so that it can go forward. And part of that process will be going forward and paying back their creditors. But additionally, it allows that debtor, that business, to maintain its place in the community, to preserve the jobs, and to maintain the relationships with its vendors, and as an ongoing business to benefit not only the debtor itself, but all of the other constituencies with which that business interacts. So who is involved in a bankruptcy case? There are several players. The debtor, who we'll be talking about a lot today, is the individual or organization that's voluntarily filed a bankruptcy petition, or in rare cases, an entity that's had an involuntary case filed against them by their creditors. But the debtor is essentially the person or entity that owes the money. The creditor is the entity to whom the money is owed. They can be individuals or organizations, but it's an entity that either believes the debtor owes them money or that the debtor believes money is owed to. There are different categories of creditors, and we'll get to that in a minute. A debtor in possession is the debtor in a case where there is no trustee appointed. Many people have heard of Chapter 7 cases where there is a trustee appointed, and that person takes over control of the assets. A debtor in possession is what we have in reorganization cases as a general rule. The business still maintains ownership and control over all the assets. It manages the day-to-day operations, and that's what we'll be talking about today, a small business debtor in possession. In those liquidation cases I mentioned earlier, and in some other kinds of bankruptcy cases that we won't be talking about today, there is a trustee who is appointed by the Department of Justice to exercise certain powers in managing how the case moves forward, whether assets should be liquidated, and overseeing the sales of assets and the payments to creditors. So talking a little bit more then about the types of debt, there really are three broad categories of debt that are most important. Secured debt is debt that is backed or collateralized by an asset. So think about mortgages that have the house as the collateral, or auto loans where the vehicle is the collateral, equipment loans. They're transactions in which the debtor borrows money and in return gives the creditor a lien or a security interest in that asset that was purchased or in some other asset the debtor has. It allows that creditor to have a little bit of extra power over the debtor because of its right to repossess that asset. Unsecured debt falls into two categories. There's non-priority unsecured debt, which is what we all have all the time. Debt that you owe for a credit card, to your doctor or lawyer or dentist. It's just someone provided a service, you owe them money for it. There's also priority unsecured debt. Like general unsecured debt, there is no collateral, no asset that is particularly assigned to that liability, but under the bankruptcy code, it has special priority. Congress has determined that alimony and child support, employee wages and benefits, consumer deposits, and tax obligations, to name the main ones, need to be paid in full in a bankruptcy case ahead of the general unsecured debts, or unsecured debts we just talked about, of doctor's bills, medical bills, etc. So those priority unsecured debts are important, and anybody filing bankruptcy needs to think about what those are and how they would manage to pay them back. So not surprisingly, the secured creditor is the creditor who holds a lien on property and can repossess that property if the debtor doesn't pay. Priority unsecured creditor is a creditor who doesn't have a lien, but has this right to payment earlier on and upfront in the case. And generally speaking, those two categories of creditors will be paid in full in bankruptcy cases. The final category, the general unsecured creditor, who has no lien and has no particular right to payment ahead of any other creditor, is likely to get the lowest distribution in a bankruptcy case. And they get paid essentially from the pool of whatever's left over after the secured and priority creditors are paid. So I'm going to turn it over now to Alex Edelman to talk a little bit about the various chapters and how these different parties and different types of debts play out in those chapters.
Thank you, Judge. So I'm going to give a pretty brief overview of the different bankruptcy chapters that creditors and debtors alike should be aware of. The first is Chapter 7, which the judge has referenced earlier, and that's a liquidation bankruptcy, and it can be filed either by a business or an individual. And essentially, it provides for the liquidation or sale of the debtor's non-exempt property, and then the distribution of any of those proceeds to creditors. And that type of liquidation is administered by a case trustee. There's also Chapter 11 bankruptcy, which is most frequently filed by business organizations, larger business organizations, but it can be filed by individuals. And that chapter provides for the reorganization of a larger corporation or partnership generally. And in that type of bankruptcy, there's a plan proposed by the debtor. Sometimes creditors can also propose plans in that type of chapter of bankruptcy. And the proposal in the plan is to pay creditors over time. And the court will hold a confirmation hearing, and then at least one class of creditors in a Chapter 11 has to support the plan in order for it to be confirmed. There's also a new subchapter 5 of the Chapter 11 bankruptcy proceeding that was just introduced to the Bankruptcy Code back in February 2020. And that's exclusively for small businesses and will be the focus of our discussion today. That type of bankruptcy provides for reorganization of small businesses, and it's a more streamlined process than the normal Chapter 11, and also a less expensive process. The way that it works is similar to the general Chapter 11, which is that there's a plan proposed by the debtor to pay its creditors over time. There is a trustee that's appointed, but the debtor still retains control of its assets and its operations. And as we'll discuss later on, the trustee is really there to assist in the process and try and help the parties reach a consensual plan. The process, like I said, is quicker than the traditional Chapter 11 and has less administrative costs. There's also a Chapter 12 bankruptcy, which is exclusively for a family farmer or family fisherman. And that can also be filed by either a business or an individual. And then finally, Chapter 13, which is exclusively for individuals. And that provides for an adjustment of debts for an individual who has regular income. The Chapter 13 debtor, like in the Chapter 11, proposes a plan to pay debts over 3 to 5 years, and it can also include voluntary sales of property. And it's important to know all these chapters because even if we're just talking about the small business chapter today, sometimes these other chapters are filed in conjunction with the Chapter 11 sub 5. Next slide, Don. Thanks. The judge spoke earlier about the automatic stay. This goes into effect immediately upon the commencement of the case. And when the case is filed, all of the parties in interest will receive a notice that lets you know that a case has been filed and actually provides really good information about the debtor's rights, the creditor's rights, what the creditor can and cannot do. And one of the things that it explains is that there's an automatic stay that's in effect upon the bankruptcy filing. And it's a very powerful and broad thing that basically creates a fortress around the debtor to give them some breathing room. And what it does is it prevents the creditor from attempting to collect any pre-petition debts. So no calls, no letters, no emails, no visits, etc. And also in the notice, I just want to point out, it will indicate that the debtor has an attorney, and all communications going forward should be with the attorney. That's a really important thing to know. It also, the stay will also prevent the commencement or continuation of any court proceedings to collect pre-petition debts, such as foreclosure or garnishment proceedings. It also prohibits the creditor from trying to perfect or enforce any liens on the property of the bankruptcy estate of the debtor if it relates to a pre-petition claim, or efforts to repossess a vehicle or any other type of property of the estate. And it also prevents a creditor from trying to enforce a judgment or setting off pre-petition debts. So it's important to know all of this, because if a creditor doesn't abide by them, there are significant consequences. And so once you know that the bankruptcy is in process, you really need to abide by this. If you know that the bankruptcy process is in place and you don't abide by it, then there are the potential for damages, actual damages for a willful violation of the automatic stay, which could include costs and attorney's fees, and even punitive damages, which can be very significant. And you really, if you know about the stay, you really can't violate it. There is a process by which you can get relief from the automatic stay, and that's typically utilized by secured creditors. That, like the judge explained earlier, these are creditors that have a security interest in collateral or assets of the debtor. And if a secured creditor wants to try to obtain a relief from stay, they need to file a motion with the court, and there's a process for it. And it will only be granted for cause. And the two things that need to be shown by the creditor is that there's a lack of adequate protection. And basically, adequate protection compensates the secured creditor for pre-petition declines in the value of their collateral. So that can be in the form of payments or liens proposed in the bankruptcy. But if there's not that, if that's not in place, the creditor can show that there's a lack of adequate protection. They also need to show that there's a lack of equity in the asset, and that that asset isn't necessary for the debtor's effective reorganization. The stay will actually terminate automatically. There's different times in the process where that's possible. But the discharge, usually it could happen when there's a discharge or when the case is closed or dismissed. In the Chapter 7 context, that would be 60 days after the first meeting of creditors. And in the Chapter 13, that would occur at the end of the bankruptcy plan. Next slide. So there's this concept of voidable preferences that creditors should be aware of. It's an ability for a trustee, a bankruptcy trustee, to avoid and recover from creditors' payments that were made within 90 days prior to the bankruptcy filing. It's a very powerful tool that trustees can use to level the playing field. And so the way that it works is payments made to a creditor totaling $600 or more within 90 days prior to the filing of the petition, if the transfer enables the creditor to get more than it otherwise would have gotten in the bankruptcy context. So if the payment hadn't been made in the 90 days prior to the bankruptcy petition, would the creditor have received the same amount in the bankruptcy process? So that's something to be aware of, and it's something where even if there was no misconduct, if the payment was made within 90 days prior to the bankruptcy filing, it could be scrutinized by the trustee. And usually what happens is the trustee sends a letter, or the debtor sends a letter indicating that there was a payment made with 90 days prior to the bankruptcy filing, and that they're investigating it, and you need to provide information to show that it wasn't any sort of preferential treatment that was received.
Great. So next we're going to talk about, and actually I just want to stay on the voidable preferences for 1 second, because I realized we didn't talk about the possible defenses. So you all are creditors out there. So there are defenses. So while it sounds like an absolute rule, 90 days prior to filing, $600 or more, there are defenses. We don't necessarily have to dwell on them, but just to make you aware, there's a new value defense, there's an ordinary course defense. So if you do suspect as a creditor that you may have a voidable preference issue, wise to consult with an attorney to see if it is in fact a voidable preference, and if you may have a possible defense. So our next slide, we're going to talk a little bit about the discharge of debts. So in bankruptcy, we have a common expression that liens survive, personal obligation is discharged, and that is in fact the case. So the discharge essentially takes that automatic stay that we talked about and converts it instantaneously from a stay that is temporary during the pendency of the case to a discharge, which is a permanent injunction, which will forever bar those creditors of discharged debts from attempting to collect. It is important to understand that the discharge only discharges personal liability. So if a debtor has, signed a personal guarantee, or a debtor has personally made him or herself obligated to a debt, that personal obligation is discharged, but the lien, the mortgage, the right to repossess, the security interest in the collateral, that lien will in fact survive. The violations of the discharge can be pretty severe. So we often talk about this concept of punishable by contempt. So that is when a creditor, notwithstanding the discharge order, acts in such a way to attempt to collect a debt that would have otherwise been discharged. The court will find that as intentional. And there was a recent case, I think in 2019, I believe, from the Supreme Court that came up with this: courts may find contempt where there's no fair ground of doubt as to the wrongfulness of the conduct. So that's where, even if, you could come up with some colorable argument, the court's generally going to say that no, you knew about the discharge, and, may in all likelihood find contempt. Similar to abuses of the relief from stay, the party prevailing will be entitled to actual damages, potentially punitive damages, attorney's fees, and costs. So the bottom line in all of this is to pay attention to the notices as the creditor. Even if you have a business relationship with the debtor, and you feel like, the debtor may not have wanted that particular debt discharged, you have to pay attention to these notices and pay attention to the fact that there are consequences. Just like the automatic stay, there are consequences to essentially violating the discharge injunction. So with that, we wanted to provide you with some foundational concepts, and I think we've covered them all, from Judges, the twin pillars of the bankruptcy code, understanding, the parties in typical bankruptcy action. Alex talked about the relief from stay, voidable preferences, things of that nature. I talked about the discharge. So armed with that information, we're now going to talk about a hypothetical that may sound somewhat familiar, because this is, the facts that we're laying out here are not hard to imagine in many businesses, certainly many businesses coming out of the shutdowns that we've experienced as a result of COVID-19. So I think, and Jeanette, correct me if I'm wrong, but all the participants here should have received the packet, and hopefully you've had an opportunity to read over the hypothetical. I'll hit some of the highlights, and then we'll go into the second part of the program, which will really be taking this hypothetical and applying it to some of those foundational concepts that we just talked about. So here we have a business, Trinkets of Vermont. It's a retail business based, at least for now, in Woodstock, Vermont. Not surprisingly, they specialize in Vermont-themed goods, cheeses, maple sugar products, things of that nature. The business was started back in 2007 by a husband and wife. They got some startup cash from a home equity line of credit that they took out on their primary residence. In 2018, they decided to expand to the internet, this new fad that's out there you may have heard of, and they introduced online sales. And they also entered into an agreement to purchase the building that their Woodstock business was located at. So they have two things going on in 2018. They're introducing this new aspect of their business and the online sales, and they're also becoming property owners, business property owners. In 2019, things are going really well. Vermont stuff is selling, off the shelves at a record pace. The online business is doing well. They decide that they're going to look to expand. Woodstock, obviously a good tourist market. They decide that they're going to expand north, and they start looking into some retail space in Stowe. They end up signing a 5-year lease. The husband and wife team personally guaranteed the lease, which is very common in these kind of situations. Not only, are the principals of the business personally guaranteeing things like a lease, but it's also not uncommon to have the business principals guaranteeing other things, other types of loans. They took a commercial loan as well, secured by all business assets and the Woodstock business, or the Woodstock building, and again, a guarantee from the husband and wife. In 2020, nobody really saw it coming. We obviously experienced some pretty significant shift in how we do business. COVID-19 with closures and things of that nature, the business slowed down significantly. They were never able to get their Stowe property off the ground. In the meantime, they ran up some expenses on an American Express card. They took a PPP. It just made me think of a song, of course. But they took a PPP, but the business itself is running on fumes. They see the writing on the wall. So right now, they're behind on the rent to the Stowe property, not surprisingly. The online sales are doing well, as many businesses are experiencing right now, since nobody can go anywhere. But not sure if the sales are going to be enough to really carry the business. What's really starting to frighten Trinkets of Vermont is the fact that they really don't have cash reserves, and they're starting to feel the pressure. Amex, creditor that hasn't been paid in a while, not a significant amount of debt, but nevertheless, debt that could be disruptive to the business. Amex is now threatening to sue. So Trinkets of Vermont consulted with some very experienced bankruptcy attorneys, of which there are many in the state of Vermont, and has decided to pursue bankruptcy relief. So you, the folks who are attending this session, are a creditor. And probably the big question you have is, okay, now what? So let's see if we can get into that a little bit. So back to you, Alex.
Thanks, Don. I think what we're going to do is talk a little bit about the timeline and what it's going to look like for the bankruptcy. And we're going to presume that they're filing a subchapter 5 bankruptcy, which is the exclusively for small business bankruptcy that I spoke about earlier. And the first thing that's going to happen, and it's actually not on here, is that as a creditor, the debtor will file the bankruptcy petition first, but then the creditor will receive a notice. And that's what I talked about briefly earlier. You get a notice of the bankruptcy filing, and that sets out a lot of really important information, like who the debtor is, the debtor's counsel. There are also going to be some really important dates on there. And I would suggest, if you receive a notice like this, that you really read through it carefully and mark down all of the dates that are indicated in the notice, because those dates will be really critical to follow. This is a quicker process than a typical Chapter 11, and you need to know the dates that you need to act so that you can be on top of it and make sure that you're protecting yourself. So the debtor will file the petition. You'll get a notice in the mail saying that there has been a bankruptcy filed, and the automatic stay will go in effect immediately. And at that point, you need to cease all communications with the debtor. General communications can be made to the debtor's counsel if necessary, but any communication or attempts to collect a debt must cease. And it's good to know that creditors can access the case docket from PACER. PACER is an electronic filing system that is used throughout the bankruptcy courts, and it's very easy to use. It's also easy to get access to, and it provides all the pertinent information that a creditor or a debtor would need in the bankruptcy process. So I would suggest finding out how to access that information because it's going to be critical. Once the case is filed, a subchapter 5 trustee will be appointed. And that trustee is really there to assist in trying to get the parties to reach a consensual plan in the process. There's an important thing that has to happen in a subchapter 5 is that the debtor has to file monthly operating reports. This is really helpful for creditors because it gives you a picture of the debtor's business operations throughout the bankruptcy. And the petition too is going to be something that anyone that has a potential claim really wants to look at closely, because in the petition, the debtor is going to need to list all of their assets and all of their liabilities, which will include, hopefully, the debt that is owed to you as a creditor. And you need to make sure that that information is accurate and that you're actually listed in there. So that's something that needs to be scrutinized. And the monthly operating reports are also something that need to be paid attention to and actually give you probably more information than you would have had the debtor not filed for bankruptcy. So it's a very useful tool. Within 30 to 45 days after the petition is filed, there will be something called a 341 meeting of creditors held. It's a really informative session. It's not something to be afraid of. It's actually an arena where the debtors attend and their counsel and the case trustee, and it allows the parties to, well, first the debtors have to provide certain information, and creditors are able to just listen, or they're also have the ability to ask certain questions about the debt that's owed to them. So it can be a very useful tool. Within 60 days of the petition being filed, a status conference will be held by the court. The creditor doesn't have to attend the status conference, but it could be helpful. And it's at the status conference, the court really meets with the parties to talk about very preliminary things, plan, timing, and other issues. So it's very good to stay apprised of all that, and attending the status conference would be helpful. And just so you know, currently up through July, all of these hearings and meetings are held electronically. So they don't need to be attended in person. I don't know what's going to happen after July. 14 days before the status conference, the debtor is going to file a report that explains its efforts towards reaching a consensual plan of reorganization. And a consensual plan of reorganization is a plan where all of the creditors are in agreement that this is the plan that should be confirmed. So that report will also be something that you would want to read closely to make sure that you understand what the debtor is going to be proposing. The next deadline is critical. It's 70 days within the petition being filed. The creditor has to file its proof of claim. The proof of claim is what establishes the creditor's claim, the debt that's owed to them, how much is owed, and the nature of the debt. And if that deadline is missed, the creditor loses its ability to collect on its claim through the bankruptcy process. So that really needs to be calendared and made sure it's met. Then within 90 days of the petition.
Alex, if I can just jump in for one quick second. So the one thing I think that's important to remember, just to relate back to our hypothetical and when Alex, is explaining the various chapters of the bankruptcy code, is that, if a business feels as though, they're struggling, they may have a couple options. They could have the Chapter 7 option, which would be a liquidation, or they, may choose to pursue relief under Subchapter 5. What's important from a creditor's perspective to appreciate is that a 7, is essentially a terminal event for the business. And the likelihood of recovering or continuing to have a relationship with that business, pretty minimal. A Subchapter 5, on the other hand, is, to go to the judge's point of, the idea of saving the business, trying to reestablish the business and maintain those relationships. So even back before this timeline kicks off, upon receipt of a notice of a bankruptcy filing, if it's a Subchapter 5, just as the creditor, keep in mind that the business is really trying to put best efforts forward to keep the business afloat.
Absolutely. That's a good point, Don. And to that point, it's really to everyone's benefit for the parties to try and reach a consensual plan, because it will enable the debtor to continue its business operations, and it will allow the creditor to continue to receive payment, which also is probably critical to its survival. So it really goes hand in hand. The plan is filed within 90 days of the petition. Usually, sometimes the date changes, but that plan is debtor's proposal for how payments are going to be made to pay back creditors. That's another thing that is critical in the process for the creditor to review and make sure that what's proposed in there is acceptable. And there's going to be a dialogue to discuss that plan with the trustee and with the debtor. Judge.
Yeah, and if I could just weigh in there, going back to this collaboration and weighing in question, the 90-day deadline is important because these cases need to move along quickly. But on the other hand, I think the trustee and the debtor and the judges all want to have the best plan possible and the most consensual plan possible. So if creditors can get involved early on, what I typically see is the creditors are joining the debtor and asking for an extension of time to file a plan, because everybody is recognizing that additional time might help them reach a consensus. And so getting it in by 90 days is not as important as getting the plan filed in a way that's likely to succeed.
Exactly. And the trustee is really going to be helpful in that process as well. We haven't talked in depth about it, but a case trustee in a subchapter 5 is much more like a mediator than in a liquidation proceeding. They really do try and assist the parties in reaching a consensual plan. So once the debtor files a plan, whether that's within the 90 days or outside of the 90 days, ultimately there will be a confirmation hearing held. And that's where the plan is hopefully confirmed by the bankruptcy court. Before that hearing, there is an ability for creditors to file an objection to the plan if there hasn't been a meeting of the minds and they haven't been able to reach agreement on the plan that the debtor has proposed, and also the ability to accept or reject the plan. So that happens, and then if the plan is ultimately confirmed, then there's this concept of a discharge that Don spoke about in great detail. But basically, there's the timing of the discharge changes depending on whether or not the plan is consensual or not. If it's a consensual plan that all the creditors agreed to, then the discharge happens upon confirmation of the plan. If it's not consensual, if not all the creditors agreed to the plan, then the discharge will occur after the completion of all the plan payments. And the non-consensual plan, the way that it works is, even though not all the creditors may happen to agree to the plan, it still can be confirmed as long as it doesn't discriminate unfairly against the non-consenting creditors, and it's found to be fair and equitable by the court. The debtor also will have the ability, after the plan is confirmed, to modify the plan. Anytime before confirmation, the debtor has the ability to try and file a modification to the plan, and the creditors will all receive notice of that and will be able to state whether or not they agree to that modification. And then after confirmation, the debtors also have the ability to modify the plan before the plan is substantially consummated, which basically means before it's almost complete. And then the term of the plan varies between 3 to 5 years after the confirmation. Don, are you going to speak to the proof of claim?
Sure. So the proof of claim, as Alex mentioned, the proof of claim is very important to pay attention to the bar date. It's the 70 days from the date that the petition is filed. But the proof of claim is really your representation to the bankruptcy process, how much you are owed. So if the debtor has listed you as a creditor, you're going to receive notice. So going back to our Trinkets of Vermont, all of the folks that Trinkets of Vermont has as creditors, all the folks that they owe money to, will be listed on the petition. The debtor has the obligation, the responsibility to list anybody he or she owes money to at the time of filing. So assuming that there's a debt out there, that creditor will receive notice. So the creditor is going to use a form, which we'll talk about in just a minute, to file the proof of claim. It's going to be filed in the same court that the debtor has filed for relief in. And again, very important, circle the calendar, 70 days from the date the debtor filed. There can be exceptions made for later filed claims, things of that nature, but generally that's a bar date. And if the claim is filed after that bar date, it will not be allowed. Non-attorneys, so the federal court system is electronic, done online, which is great. But if you are a little intimidated by the prospect of having to file a proof of claim online, need not worry, because non-attorneys who are filing are not required to file electronically. So creditors can file without an attorney, but this is important. If it's a corporation, you have to have an attorney appearing in the case. So unfortunately, you may incur some additional legal fees in having to get a proof of claim filed. but that certainly shouldn't be, an obstacle to getting it done, because the consequence, as we just talked about, of not filing a proof of claim is not being included in the plan. You have to file that proof of claim to get paid. So there are some things that by rule are required to be included in the proof of claim. Obviously, you want to include your name. That helps to make sure that the payment gets sent to you if there is one. The notice and payment addresses, of course, the claim amount, the class of claim, and then the basis for the claim. And the class of claim goes back to that concept, whether it's a priority, general unsecured priority claim or a secured claim. If it is in fact a secured claim, you need to include proof of the collateralization, copy of the mortgage, a copy of financing statement, things of that nature. You have to establish the basis of that claim. The takeaway really, with respect to Trinkets of Vermont, is to just make sure when that notice of the case is sent out, you pay attention to that 70-day bar date, and you get the proof of claim filed in advance. So we do have some resources that are available directly from the court's website. There is the official form B410, which is the proof of claim form. I've provided a link there. It's, again, directly from the U.S. Court's website. And the form is, believe it or not, there was a forms modernization push a couple years back. The form is relatively easy to fill out. With anything else, you have to read carefully and make sure you're answering the call of the question, but the form is relatively easy to complete. And then you can also sign up to receive notices. So if you are not, if you do not need to necessarily hire an attorney to file the claim, or if you've hired an attorney but you just want to keep track of the notices yourself, you can actually sign up to receive the electronic notices associated with the case. And that's the link to make that happen. Pretty easy to do, but definitely recommend, if upon getting notice of a bankruptcy filing, you want to avail yourself to all of these resources that are out there. It's back to you, Alex.
So these are some tips for creditors to keep in mind in the bankruptcy process. The first is to go online, and this, Don's information that he just provided is one way to get online. And I talked about PACER in the beginning. You can get all of the information about the bankruptcy proceeding on the PACER website, which will have all the schedules and the statements that are filed by the debtor, and it'll give you a sense about what the case is about and where the creditors stand, where you as a creditor stand in comparison to the other creditors, how much your claim is in comparison to other creditors, how many other creditors are there, what are the debtor's available assets, what exemptions are the debtors claiming in connection with their filing. All of that information will be online on the bankruptcy petition and the schedules that are attached to it. So that's the first thing that needs to happen so that you can keep yourself apprised of all the pertinent information. The next is read the plan. The nice thing about the subchapter 5 plan is it includes a little bit more information. It's just not numbers. It will have a brief history of the business. It'll include a liquidation analysis if the business had to liquidate, what it would look like, and the projections about the debtor's ability to actually make the plan payments. So that will be a really helpful guide to determine whether or not this plan could be feasible and whether or not, the debtor's reorganization is a possibility. And it's something that, like we said earlier, the really important part of this process is to start early and to try and work with the debtor to reach a consensual plan, because that's in everyone's best interest. And if you're aware of all of the nuances and intricacies of the plan, you'll have a better opportunity to do that. Whether or not you may have questions about the plan, and there are resources. The trustee is a great resource. The trustee will know a lot about the case and is there to answer any questions. Like I mentioned earlier, the trustee really acts as a mediator to help the parties reach a consensual plan. So questions really can be directed to the trustee. The creditor could also reach out to debtor's counsel if they have particular questions about their claim. It's good to establish that communication early on so that you know the parties, they know you, and you work together to try and reach a plan that works for everybody. If the parties can't resolve their differences, the court will ultimately be the decision maker as to whether or not the plan can be confirmed. So, if you make all the efforts with the debtor to reach a consensual plan and it's just not working out, well, then the judge will be the ultimate decision maker as to whether or not the plan should be confirmed. Like I mentioned earlier, this process is a lot less expensive. And the parties don't need hearings to resolve their differences. There are things in place to allow the parties to talk, and whether or not it's attending the 341 meeting of creditors, which we would suggest you do, because it just is an ability to speak with the parties and also to keep, all to understand all the things that are going into the debtor's plan and the process going forward. And it really can be a collaborative process where everyone works together to try and reach a plan that will allow not only the debtor's business to survive into the future, which is obviously good for any creditors of that business, but also to make sure that the creditors are treated fairly and receive payment that they're due.
So the last thing, and this is, it almost, the slide doesn't seem to, it almost lacks context in a way, but remembering our Trinkets of Vermont hypothetical, they did enter into this 5-year lease for commercial space up in Stowe. Well, commercial leases in general are complicated in the context of bankruptcy. So we wanted to provide a little bit of an overview, but if you as a creditor own commercial real estate and you have a tenant who might be in the process of filing for bankruptcy, really whatever chapter relief they might be pursuing, it's important to understand how leases are handled in the context of a bankruptcy. Really important, not to plug the bankruptcy bar, but really important to consult with an attorney if you do own commercial property with a tenant who has pursued bankruptcy relief, because it's complicated. So the one thing we talk about in the context of bankruptcy is this concept of assuming or rejecting the lease. In some instances, a bankruptcy filing may be strategic. For example, in our Trinkets of Vermont, they may realize that they entered into this lease that they just cannot afford. And business, the way the business is going, they need to get out of that lease. Well, they could, just default on the lease and then deal with the consequences in state court, or they could potentially file for bankruptcy where they would have the option to have the trustee either assume or reject the lease. So timing is critical, and that's why it's so important to consult with a bankruptcy attorney if you do own commercial property that is occupied by a potential debtor. It's 120 days from the filing or confirmation, whichever is earlier. Once and going back to this concept of the automatic stay, when the case is filed, the automatic stay goes into effect, and that will prohibit you as the commercial landlord from doing things like lockouts, things that you may otherwise be able to do, quote unquote. The bankruptcy will prevent you from doing that. However, if the lease is rejected, the landlord can take possession of the property. Just like any creditor in the context of the bankruptcy, you want to file a proof of claim, which can be for the pre-petition rent or future rent, but within certain limits. If the debtor or the trustee decides to assume the lease, meaning they're going to continue to honor the terms of the lease, there has to be an adequate assurance with respect to the default. So assuming, in the case of Trinkets of Vermont, for example, where it's clear that at the time of filing, there was a rent arrearage, they would have to provide, if they decided that they're going to maintain that property, they would have to provide adequate assurance that they are going to cure the default. And it has to be done in a reasonable period of time. They don't have 15 years to cure a pre-petition default. They have to cure the default within a reasonable period of time. The takeaway here is a bankruptcy filing to a commercial landlord is not, the end of the tenancy. It can, in fact, be a way that, you know, the rent is caught up and the tenant is brought back into good standing. They're very complicated, and it really is, again, not trying to drum up work for the bar, but it really is good to, you know, consult with an attorney if you own commercial property subject to a lease from a debtor tenant. I'm sorry, Your Honor. Go ahead.
No, go ahead. I was just going to point out that there are also very strict time limits. And, you know, as a bankruptcy judge, I have discretion on extending some time limits, but there are others that cannot be extended. And some of those types of very firm deadlines are in the context of commercial leases and when they can and can't be extended or assumed or rejected. So I just want to underscore Don's point about how complicated these are, and that if you are in the position of a landlord when a tenant files bankruptcy, time is of the essence. You really do need to contact an attorney quickly or take some action as quickly as you can to make sure that communication is open and process is begun to determine how to handle that lease.
Yeah, and I actually believe that is it for the substance of the presentation. I know we'd like to open the floor up for questions. And then obviously this resource, I believe you guys were going to take either Kate or Jeanette, we're going to take back over for a brief minute.
Absolutely. So I will be reading off questions that have come in, and I'd like to encourage everyone, if you have questions, to please post them in the Q&A section. I'm going to start with the first question that we had come in for the panel. This question asks, in the case of a debt that is discharged or secured by a lien, you said that the lien survives. Does that mean that the creditor can still collect on the lien?
I can take that. For me, the easiest way, I think, to understand this concept is that when parties enter into a secured transaction, like a mortgage or an auto loan, there really are two distinct parts to that. There is the note that the debtor signs that says, I promise to pay you $10,000. Then, as a separate agreement, the debtor says to the creditor, I also promise that if I don't pay, you can come take back the car. When a discharge is entered, that note, that promise to pay back, excuse me, is essentially torn up. It's gone, it's extinguished. The debtor is no longer obligated to pay. However, the transaction involving the granting of a lien is still in effect. And if the debtor doesn't pay, the creditor can repossess. So the two takeaways, I think, are, first of all, that yes, the lien remains and the creditor can enforce their rights under that lien, whether it's an auto lien or a mortgage or you know, any other type of collateral. The second is that you can't do that while the case is pending unless you get relief from stay. So if the debtor is not paying you and you have security, you can go in, you can either go into court and get relief from stay and pursue your rights against that piece of equipment or house or car, whatever it is. Or, you know, you can wait until the end of the case when the stay automatically is lifted, and then you can do it without getting bankruptcy court approval. So I hope that answers the question. I'm happy to give any follow-up to that if it's still not.
And please, as we're doing this, if it doesn't answer the question, follow up. I'd be happy to read your follow-up request. Another question. This seems like a complex process. Should a small business who is a creditor hire an attorney to assist them through this?
Well, yes. I think, you know, as with any area of law, I mean, bankruptcy is, you know, a very complex area of law. And there are a lot of pitfalls that the unknowing creditor can step into if they, you know, elect to proceed without an attorney. again, not trying to drum up work for the bar, but I think you'll find that it's expertise worth paying for as a creditor. To make sure that you're doing things right, and to make sure that your claim is properly filed, to make sure that you get, paid, and to have somebody on your side as the creditor to really explain the process. Google is great. You can certainly find answers to a lot of questions on Google, but Google is not a substitute, just like WebMD is not a substitute for a doctor visit. Google is not a substitute for experienced licensed attorney to help navigate through these situations. And even if it's to find out that, sure, you can do it on your own, and here's how you would do it, I think that advice would be worth, the money paid to avoid maybe missing an opportunity to fully participate in the process.
I agree with Don, but I just want to point out that for some, getting an attorney shouldn't be a reason. If you feel like you can't afford attorney or that you don't want to get involved with attorney, it shouldn't be a reason to preclude you from participating in the process, because a creditor can represent itself in the process and can file a proof of claim without an attorney. So while it would be wonderful and wise to seek advice if you felt that the process was complicated and that you didn't understand all the nuances involved, if you can't do so, it is a process in which you can represent yourself, and you can file the proof of claim, and you can, stay on top of the dates without an attorney representing you.
Many businesses are LLCs. Does that mean if they're an LLC that they will have to have an attorney represent them? Don? Alexandra?
So any business, any entity should be represented by an attorney in the bankruptcy process. If the debtor is an LLC or a corporation, they need to be represented by counsel. Yes.
Okay. And sole proprietors, are they counted as individuals, or are they counted as corporation?
If it's a sole proprietorship that hasn't created any sort of entity, then they most likely could represent themselves. That's a hard one. What do you think, Don?
I think they can. If it's it's somebody who's a DBA, I believe they can. I mean, I suppose we could seek an advisory opinion from the court on this one, but but I believe that a sole proprietor could file an individual proof of claim.
Right.
It's that distinction between the entity, if you've incorporated or formed an LLC or something along those lines, where you would have to have an attorney file. But I certainly, yeah, Your Honor.
Yeah, and I think that the important distinction is that under the case law, an entity can't appear in court without an attorney. So that even a corporation can file a proof of claim on its own.
Exactly.
And so if it's a DBA, so that the primary sort of attribute of the business is an individual, it's a person, then they can appear in court without an attorney as well. But if they are a corporate entity, then they cannot appear in court without an attorney. But they can go to a 341 meeting, they can contact the trustee, they can certainly read the notices, they can do all of that and then just use the attorney for the more technical questions that might arise in terms of how their claim is being treated or whether they have any particular rights that they need to specify.
So there are ways to sort of limit the expense that goes with this for
Exactly.
very
Definitely.
small businesses.
Yeah.
Okay, next question. If you are not listed as a debtor and 70 days passes, is there any recourse? You knew this question was going to be out there today.
I think what they meant was as a creditor.
Yes.
If they're not listed as a creditor. And the bankruptcy code is a little bit complicated on this, but what it really comes down to is whether the creditor has notice. So if the debtor makes a mistake and fails to include the creditor as on their schedules, but the creditor knows about it, they're going to be held to that 70-day limit. If the creditor truly has no knowledge of the bankruptcy filing, there are avenues the creditor can pursue to ask to get an extension of time based on lack of notice. But the sort of classic example is particularly in a place like Vermont, where it's a big, small town, and the vendors and the businesses tend to know each other fairly well. If through the grapevine, the person who is owed money, the creditor, hears about this bankruptcy, they have some responsibility to follow through. And so, it's always better to avoid having to go to court and litigate a question. And so rather than say, well, I want to sit back and make believe I don't know and wait for them to send me the formal notice, that's dangerous. Because if the debtor can establish what's called actual notice, that they really did know about it, they will not get an extension of time, and they will be held to that 70-day time period. Again, going back to the bar, my sense is that the bar is very careful about trying to get as much information as possible to make sure that all creditors are listed, because it's in everybody's best interest to do it right the first time.
And actually, if I can say one thing, and I think, and correct me if I'm wrong about this, but I think it's a very important distinction to make, that a business can file a proof of claim, but it's just participating in court. So if there's a relief from stay proceeding or something along those lines, that's the instance where the entity would need to hire an attorney. But certainly the idea of filing a proof of claim is something that a business can do without having to retain an attorney. So if you see the plan and you're satisfied with the plan and things of that nature, then you can go ahead as the business and file a proof of claim without having to retain an attorney. It's just participating in court or appearing in court where that you would need to retain an attorney.
Right, and we just need to keep the timing correct, though, that the proof of claim is going to be due before the plan.
That's true. That's true. Right.
I mean,
right.
because in a normal Chapter 11, it wouldn't be. But in a sub 5, the timeframes are all condensed. So the proof of claim is due 70 days and the plan is due 90 days after filing.
Right.
Thank you. We have another question. Do small business owners have a choice on when to offer a personal guarantee, for example, on a lease?
Yes. Always.
Always.
I mean, the problem is whether the lessor will sign the lease without a personal guarantee. I mean, my experience, as an attorney before I became a judge, was that nobody gave a personal guarantee unless they absolutely had to. And certainly that's what I would advise my clients as an attorney.
Right. Well, if you were representing the business owner, however, if you're representing the creditor, who's potentially looking to make sure that you have someone to go after in the event of default, you may insist on that personal guarantee. Businesses that don't have, a huge track record, maybe it's a business startup or something along those lines. Trinkets of Vermont, for example, having to make personal guarantees. That's really not that uncommon. If I'm representing the debtor or the business owner, I'm of course trying to talk them out of signing personal guarantees, but Alex may be representing the creditor and say, no, you need to get that personal guarantee. You want as many people as possible that you can go after.
Sure. Yeah, it will just, if you are the landlord, it definitely gives you some extra added protection and some recourse if there is a default and the business just doesn't have the assets. You may need to go after the tenants personally if they will agree to sign a personal guarantee.
Okay. Our next question. When the notice of bankruptcy comes to the creditor, is there some language that says exactly when you have to hire an attorney and when you can do it yourself? I think we talked about that a little bit just a minute ago. So
unfortunately not. No, there's no exact date on when that has to happen. And as we've said, it may not have to happen. The creditor does have the ability to file a proof of claim and to attend the 341 meeting of creditors without an attorney. And if it becomes apparent that it's a complicated process that the creditor just doesn't understand or feel comfortable with, or they feel that, you know, they're going to need to enter into the courtroom to dispute part of the plan or something else that's going on in the bankruptcy, then that would be the time to at least speak with an attorney to get some advice and to determine whether or not you actually need to hire them.
Great. So there's one more question here. And if there are any other questions, please be busy typing because we'll wrap up after this. Do attorneys who represent creditors work on an hourly basis or contingency basis as percentage of the settlement?
Well, I can speak from experience because I happen to represent a lot of creditors. Generally, it's done on an hourly basis, not on a contingency basis. That doesn't happen, but there are arrangements for flat fee payments and other ways of paying an attorney to represent a creditor at a bankruptcy.
Excellent.
I think one point that we haven't touched on all that directly is that in addition to the trustee being a great source of information, the bankruptcy court clerk's office can also be very helpful. No one who works in the clerk's office can give legal advice, but in terms of helping to point someone who calls to forms on the website or answering questions about when meetings of creditors will happen, how long, you know, how far apart they might be, where they'll be taking place, you know, that sort of information, you know, is available from the clerk's office. And as Alex, I think, pointed out earlier, there's also just a lot of information on the court's website and on the US court's website as well. The bankruptcy process is complicated, but I think there's a very strong sense of making it as accessible as possible and to try to help everybody who's involved in the cases understand what's coming next and what you can do, you know, through these various websites and official forms.
Earlier, we spoke about what happens when you hear about somebody going bankruptcy and you potentially would be a creditor and you weren't listed. What is the process and how can someone who's in that situation learn about it more formally?
Well, they can call the clerk's office to ask if there's a filing by that particular person or entity, but they can also go on PACER, which is the Public Access for Court Electronic Records. And it's a very small fee. I haven't checked lately, and if Don or Alex knows, they can tell me for sure, but it used to be $15 to sign up for PACER. And once you have that, you have access to the docket. You can do searches. You can search by either a name, a social security number, I think also an address, or a case number. And so you can go in to find out if that business has filed for bankruptcy. And if it has, then you can access what's called the case docket, which indicates everything that's been filed in the case. And it has a hyperlink to each of those documents. If there are hearings held, have been held already in the case, you'll also see on the docket hyperlinks to an MP3 of each of the hearings. So each of the hearings in every case in the bankruptcy court in Vermont, and different courts do it differently, but here all of the hearings in the bankruptcy court are recorded and are promptly posted on the public docket and accessible through this hyperlink. It just links you over to this easy to play MP3. So there are many ways, either through human contact with the trustee or the clerk's office, or electronic by just reviewing the records, or more hands-on by looking at the documents or listening to the hearings, that enable creditors and other parties who are just interested in the case to get access as to what's gone on so far and where things stand.
So a note from one of the business advisors, I did have a client who misunderstood the notice and missed the 70-day deadline, and the clerk of the court was extremely helpful. Unfortunately, they were not able to file a claim, but they did feel heard and assisted, so thank you to the court.
Oh, good. Glad to hear that. Yeah, and like I say, it's a fast process, and the benefit, of course, is that you get this business back up on its feet quickly, or if it can't be done, everyone knows fairly quickly what's happening. The other side is, you can't be asleep at the switch because there are dire consequences if you miss these deadlines.
Absolutely.
And I think one of the really important themes of the subchapter 5 is communication. The process is really geared towards arriving at, a consensual plan. And, you as the business owner or the creditor may be aware of things that indicate potential problems with the business. A business who was paying, net 30 regularly, and then all of a sudden is now net 60, net 90, asking for extension, whatever. You may notice that a business is struggling. And while they are certainly hard phone calls to make, a lot of the work, even leading up to a subchapter 5 before the debtor files, can be done, just through communicating, the parties communicating, and certainly after the subchapter 5 is filed, actively participating in that process, recognizing that the business has pursued at, a financial cost, at a cost to, potentially, while misplaced, business reputation, has elected to pursue bankruptcy relief with the intent to reorganize. The business at that point is not just walking away and closing the doors. They're actually attempting to reorganize. And I think as the creditor, acknowledging that and then participating in good faith in that process will bring about a great result that'll save jobs, that'll keep, businesses paid, things of that nature. So, communication, I think, is really critical.
It's a great point, Don.
Yeah, and it often at times is really to the benefit of the creditor as much as it is to the debtor. Bankruptcy really does level the playing field, and it allows the creditor to receive payment that it may not have otherwise received, and it allows it to continue to receive payments in the future because the debtor survives and is able to continue its operations.
There's
So we have
really nobody that benefits when the business goes down. If the business can't reorganize, the negative consequences of that really ripple through the community. And so there's a vested interest really in all of the parties in trying to help that business figure out how to restructure its operations. Maybe it decides to change the nature of the goods that it sells, or to streamline or to expand. I mean, figuring out what will be able to enable it to become profitable and stay in business, as Don said, continuing to employ people and to continuing to buy goods and services from other people in Vermont, and maintain a positive impact on the economy.
So we have one more question. We have all heard that personal bankruptcy follows you for 7 years. How long does it affect the business and also the business owner? Does it follow in the same way?
Well, as debtors counsel, I wouldn't mind fielding that question, but I'll certainly defer. The concept of when I'm working with a consumer debtor, we talk about a Chapter 7 actually stays in your credit report for 10 years, Chapter 13 for 7 years. But the important thing is the filing of the bankruptcy, the relief begins instantaneously. And while certainly that notation may be on a credit report for 10 years or 7 years, depending on the chapter, the reality is the debtor's credit, while it takes a hit for sure, begins to improve almost instantaneously, because the automatic stay and then subsequently the discharge prohibits all those attempts to collect debts. So creditors can no longer report negative information to credit bureaus. If there's a pending court action, that court action is stayed. So while it does follow, and it's a good way to put it, it does follow you for a period of time as a consumer debtor, the reality is within a relatively short period of time after a bankruptcy filing. In fact, I'm almost appalled sometimes at how quickly debtors will start to receive credit card, applications and things of that nature, which I discourage them from, signing on. But the credit will begin to, rebound almost instantaneously. So the credit lobby really wanted to make sure that, there were some teeth, there were some consequences to filing for bankruptcy relief. So we have this 10-year, this 7-year period that it stays on the credit report. But the reality is, the further you get away from the event of the filing, the less of an impact the bankruptcy really has. Businesses, on the other hand, the business owner personally, may be impacted if the business owner elects to pursue bankruptcy relief. They may be impacted by those 7 or 10-year limits. The business itself, from a credit perspective, sure, there's going to be a consequence, but it doesn't, and Alex, I don't know, you may be able to answer this a little bit better than I from a business client perspective, but, I don't think the consequences of a bankruptcy filing are as dire or detrimental as they may appear.
No, I would agree with that. It really does come into play with personal bankruptcy. So if an owner of the business files personally, then like Don said, there are some credit implications, which although they seem pretty significant, they do ease over time. But when it comes to a business, those ramifications really don't come into play with a reorganization.
Thank you. All right, we have no more questions, so I'd like to turn it over to Linda to wrap things up.